Once again, this is Checker hosting our Background Screening 201 with Cindy Hansen and Megan Nichols from Troutman Sanders. So I'll go ahead and hand it over to them right now.
Thanks, Jen, and thanks everyone for attending this afternoon. We appreciate it. This is Cindy Hansen. And there we go. This is Cindy Hansen. I'm with Troutman Sanders, and I spend most of my practice litigating cases that are brought under the Fair Credit Reporting Act and similar type state statutes relating to the use of background checks in employment screening. With me, I have my colleague, Meg Nichols. Meg also spends a lot of her time in FCRA and state law issues. Meg's focus tends to be more on compliance issues than litigation issues. So I think we complement each other well. And what we wanted to do today was look at some of the issues that a company might face as it is growing and perhaps going into new areas, new states, new lines of business. What are some of the challenges they may face with respect to running background checks? And then wanted to touch on some of those challenges. And then Meg is going to touch on some of the ways that perhaps you can minimize those challenges and deal with them. So just as a quick reminder, the reason everyone is so focused on maintaining compliance with the law, obviously, is predominantly driven by the Fair Credit Reporting Act. Under the Fair Credit Reporting Act, which has a variety of requirements, consumers can bring private causes of action for statutory, actual, and punitive damages plus attorney's fees. And what we have seen, I would say in the last 5 to 7 years, is a real increase in the potential or the filing of class action lawsuits. And what most plaintiffs do when they're going to file a class action is they seek the statutory damages under the statute, under the FCRA, which are between $100 to $1,000 per violation. So if you have a process that you follow, in each and every background check you run, but there is a problem with that process, then every time you've run it, there's a potential for a violation, and the plaintiffs would argue they and their class are entitled to between $100 and $1,000 per violation. So you can see, particularly as you begin to scale and grow, and you begin to do this repetitive process more and more, you would run afoul of the statute more and more times. Hence why class actions become more and more attractive to plaintiffs' bars. What I didn't put on the slide is the other real risk, obviously, is state laws. There are many, many states, and now many even down to the county and city levels, are passing innumerable statutes and regulations regarding the use of background checks. And many of those have private causes of action. And again, you running afoul of them can quickly lead to increased exposure. So how does increasing your business increase your risk? You might say, well, I have a good process, and if I do it 10 times or 100 times or 1,000 times, as long as it's a good process, it's going to work. That is true, but typically when you grow your business, you also begin to do new things. So particularly in the use of background checks, one of the real potential areas that you need to stay focused on, and we'll talk about this a little bit more, is state law. So if you're going to begin to do business in a new state, begin to have employees in a new state, or have employees who reside in a new state. Maybe you don't actually have a business operation there, but you begin to have employees in that state. You now need to start complying with state laws. And if they're in any of the largest metropolitan areas in the United States, New York, San Francisco, LA, Washington, D.C., you all of a sudden now have county and city regulations on top of it. So you need to stay aware as you grow and expand of the ever-increasing number of states you need to be concerned with. You have a good process, and when you run it 10 times or 100 times, it works great. If all of a sudden now you're going to do it 1,000 times or 10,000 times, there's more potential there for error because you're going to run that process more. You're going to run through that process more and more times. And so you need to be thinking about, as you're scaling up, you're going to introduce more people into the process. More people just necessitates more human error. So you need to be thinking about your processes, what can be automated, what can be maybe more centralized. Maybe you had one person doing 3 or 4 things, And rather than having 4 people doing all 4 of those steps, maybe you break the steps down and you dedicate a particular person or a subset of people to one particular part of the process. In this way, you train those people very well and they can control the process. Another avenue, maybe as you're growing in your business, maybe you're a screening company, maybe you are a franchise type company, your business model is going to change. And so now all of a sudden you're going to have new actors and new third parties that are going to be in the process. And those new parties, that new business model increases the opportunity for an error. So you need to be thinking about that on all levels. So what can you do? And we'll be talking about some of these things. Being proactive is obviously the best thing to do. Think about the issues before you scale rather than trying to plug the holes after you do it. So, you know, if you were a smaller company and you were checking employment history, maybe you had a limited number of job descriptions, you had maybe 1 or 2 sets of criteria that you would apply. Now, as you grow, you're going to be hiring people for many more different types of jobs, and therefore maybe you need more diversified requirements on what types of criminal infractions will impede a person's ability to get a job. You know, your criteria for a senior level management person is necessarily going to look different than maybe a much lower level staff person. Or if your criteria for somebody who's going to come into contact with the public or come into contact with children is going to look very different from somebody who, let's say, maybe just works in a warehouse. So as you grow and your types of jobs grow and become more varied, you need to really be thinking about, why am I checking this person's criminal background? What am I looking for? And really start to tailor your needs. As I said, what states and cities are you in? What states and cities are you moving to? This is an ever-growing challenge to keep up with all of the states and the cities that are constantly passing new laws and regulations. You also have issues of your company is headquartered in one state, but the employee is going to work in a satellite location. Okay, fine, but the employee actually lives across the state line in yet a third state. Which state's laws should apply? That is an issue, I'll tell you, that has not been fully decided at this point. And so you need to be thinking about which, you need to understand all states' laws and try to figure out which state's going to apply. A lot of times what we recommend is you apply the strictest law in those situations, and that way you're covered, but you need to obviously know what is the strictest law. To give you some idea of where state laws are real, where we're seeing state law, is obviously first ban the box, which Meg is going to talk about, I think a little bit longer in. Actually, I am. And so we'll talk about ban the box. That has been a movement, and we have seen it growing and growing, and every single day we're seeing more states implement that. Disclosure and authorization. You've all seen the typical Fair Credit Reporting Act disclosure and authorization, and you've probably seen some that have kind of state law disclosures. There are definitely some states where if you do business there or you're going to hire an employee from that state, you have to give an additional notice. Sometimes that notice is as simple as a sentence. Other times you have to give that employee a whole nother set of consumer rights in a separate document. States like California require that you actually identify the consumer reporting agency who's going to be running the background checks. And so as you add more states, you obviously now add more state law notices that you have to give on your disclosures. Please, 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 please put those disclosures separate from your Fair Credit Reporting Act disclosure on a separate screen or on a separate piece of paper. But you need to make sure you're navigating all of those. If you used to only practice in one or two, have a business in one or two states, and now you start to expand, you need to understand what those new states require, because there are, it is somewhat of the usual suspects, California and New York, but there are also some outlier states that you wouldn't necessarily think of as requiring something more, and yet they do. So definitely be looking at that. Same thing with authorizations. different language can be required, and so you need to be looking at all of those things. Next issue is disparate treatment. So you need to obviously treat all of your employees equally with respect to criminal background checks, and so you have to have a non-discriminatory explanation for your policy. You have to be able to explain why certain criminal records or people with certain criminal records should not be hired for a particular position, and you need to articulate a reason for that. And this really comes into the idea of disparate impact. So you might have a, on its face, very neutral policy. The most neutral of all of them on its face is, I will not hire anybody with a felony conviction. Don't do that, but it's neutral on its face. The issue becomes, though, what is the actual impact of that policy? And so you can't have that one size fits all. You need to look at the job. What are the criteria of that job, both in terms of will it have access to money? Will it have access to the public? Will they have access to children? Are they in a secluded place where they could potentially do harm to another person? You need to look at all of those aspects of your various jobs and then come up with a matrix, if you will, of the criminal records that are related to that job. And again, as you grow and you have more positions, you're going to have to have a more detailed matrix, because if you are challenged on this, you need to be able to show why it was a business necessity that, let's say, somebody with a drug conviction not have a certain type of job, or somebody with a theft conviction not have a certain type of job. So you need to be able to justify that. As I said earlier, one of the biggest avenues or areas where we have seen state and local laws and regulations passed is this concept of ban the box. What ban the box is, if you remember, it was commonplace up until a couple of years ago for employment applications to ask, have you ever been convicted of a crime? And typically it was limited to 7 years, but have you ever been convicted of a crime? If yes, please disclose what it is here. There's a real movement among many that by asking that question up front, employers, if people were honest and did disclose the fact that they had some criminal conviction, that they were being excluded at the front end of the process and were never getting the opportunity to continue through the process. So the idea behind ban the box is that we're going to move the issue of criminal background, criminal screening to later in the process. And so you no longer, in many places now, you cannot ask the question on the initial application. You have to move it. And here's where it gets tricky with the states. The states are all over, and the counties who are doing this are all over this. Some say you have to move it to after the initial screening. Some say it has to be, you can ask at the first interview. Others say you can ask after the first interview. And others have said you cannot ask about criminal history until after a conditional offer is made. So those are multiple points in the same process. Obviously, if you're hiring people across the country, you would need to know for each of those places where the various touch points are. A lot of rules of thumb that people are using, as I said, when you're dealing across multiple jurisdictions, you go with the strictest requirement. So a lot of companies have moved to, across the board, they do not ask about criminal history until after a conditional offer is made. So they've moved it from the beginning of the process all the way to the end of the process. Obviously, pluses and minuses to that. Get a candidate all the way through the process, and now you learn about a significant criminal issue. Obviously, you've invested a lot in that candidate, and so there's gives and takes here. But you really need to know what your jurisdiction requires. I do see this as a continuing area. I think this will be a growing area of litigation. I also think this will be a continuing area of state regulation and county regulation. Another sort of issue that you can run into is this an issue that came up in a case in front of the High State Court in New York, Griffin versus Syrah. And to give you a little bit of background of this case, the plaintiff applies for a job with Astro Moving Company, the local moving company in New York. But Astro is a contractor for Allied Vans, obviously a much larger trucking company. And the allegation is that Astro, who would have been the employer, Astro would have been the one giving the W-2 to the plaintiff, if you will. They run a criminal background screen, and the plaintiff is rejected based upon that criminal background screen. When the plaintiff sues under a New York statute that basically prohibits any discrimination on the basis of criminal conviction history. But the plaintiff's argument that the plaintiff also sues Allied, and Allied takes the position, well, we're not liable under this New York statute because we're not the employer. And so the court in New York did two things here. First, what it did do was it gave a little more definition around the idea of who is the employer. And the New York court set out a four-part test, which you see there on the screen, as to trying to figure out how do you define the employee-employer relationship. You look at things like the selection and engagement of the employees, who's going to make the payment of wages, who has the power of dismissal, and who controls the servant's conduct. And so on that, the case was noteworthy for that because it began to give New York better context of who's the employer. But the worrisome part of this case is that this New York statute also has a provision that someone can be liable if they, quote, aid and abet somebody else's violation. So if you help somebody, or are part of a process that leads to the employer violating the statute, then you can be liable, even if you are not the employer under this definition. And so where this becomes really tricky is, in this case, the reason Allied got brought in was Allied had dictated to the local trucking company which criminal records would be would cause the applicant to be disqualified from working at Astro. So you come into the job with Astro, but Allied is dictating the terms. And so here, the case against Allied is going to be able to continue because even though Allied was deemed not the employer, they can still aid and abet the violation of the statute. And so to the extent that you are a screening company and perhaps you're doing some pre-screening, or you're a franchise company, or you are in any way that you, as the one step removed actor, are beginning to dictate which criminal violations will be potentially disqualifying, you may have potentially liability under the statute. This case in particular is sort of at the beginning. One is the decision of the Court of Appeals was early on in the case. It was an attempt to basically limit this aiding and abetting section of the statute, and the New York Court of Appeals took a very broad view. So to the extent that as you're growing your business model, you need to be aware of statutes like these, where even though you're not the employer, your involvement in the use of criminal background checks could subject you to potentially some liability. I think there is still much more litigation to occur in this Griffin case and under the statute generally. But this gives you an idea of what you need to be aware of because these are things that you may then want to begin to take care of through indemnifications and contracts or through better contracting language in an attempt to avoid these types of situations. But you have to be aware of it in the first place to even know to take those proactive measures. And so this is one area where I think you'll see some increased litigation. Now I'm going to turn it over to Meg, and she's going to talk about some other state statutes.
Thanks, Cindy, and good morning or good afternoon, everybody on the phone. So the first thing I wanted to kind of talk about was the California Fair Employment and Housing Council and the new regulation that they set forth that it becomes effective July 1st of this year. We've received quite a few questions from employers in this area, so we thought it was worth quickly addressing. This new regulation governs the consideration of criminal history in employment decisions. Specifically, employers are prohibited from considering criminal history in their employment decisions if doing so would have an adverse impact on an individual on a basis like race or religious creed or color, that the employer cannot prove is job-related and consistent with business necessity. So this idea of business necessity is a new one for California. It used to just be a job-related requirement, but they've added this additional business necessity. And it's up to the employer to prove those too. So how does an employer go about doing that? They need to have an appropriately tailored policy. And that policy has to take into account the nature and gravity of the offense or conduct, the time that has passed since the offense or conduct, and or the completion of the sentence. So if there was a conviction and a sentence, how long ago was that person, that candidate or employee, released from incarceration or custody, and the nature of the job sought. So is there a connection between the conviction or the record and what the person will be doing in their job? So there's also some specific convictions that are prohibited from consideration. So arrest records that didn't lead to a conviction, non-felony convictions for possession of marijuana that are 2 years or more old, those cannot be considered under this new statute. And then employers have a rebuttable defense if they're required by law to check certain criminal records. That's a rebuttable defense, but then the employees can actually come back and say, well, yeah, but you had a less discriminatory way to determine if I was qualified other than looking at my criminal records. So the other piece to this particular regulation that has a huge impact on employers right now is the pre-adverse action notice requirements. So I'm sure all of you are aware of your federal Fair Credit Reporting Fair Credit Reporting Act notice requirements in the event that you're going to take adverse action against a candidate or an employee based on their criminal records. But this new regulation for California actually adds an additional element in which you have to notify the candidate or the employee of the specific disqualifying conviction that you're considering to be the genesis of your decision. So the individual has to be notified of that specific disqualifying conviction, and then they have to be given a reasonable opportunity to prove that the information is factually inaccurate. So that's something that we kind of want to keep in mind as we walk through this, that California is an example of one state that is up and coming of something that you want to consider as, is this applicable to me? What do my policies need to say? Do I have a business justification or a need? And is my policy appropriately tailored? Next slide. So let's kind of shift gears a little bit. We've talked quite a bit about what is required under the law, what you need to take stock of. Now let's look at your hiring process. Next slide. The first thing that we're going to look at is policies and procedures. So what do you have in place currently today? Where are you going? And especially as you're considering scaling your company, either size-wise or into more jurisdictions or a change of business model, as Cindy went through earlier, you want to take a look at your background check report policy. Maybe it's a consumer report check policy. There should be some sort of a written policy that you have regarding when you're going to actually look at a candidate or a current employee's criminal history. When will that report be ordered? This comes back to the ban the box issues. What does state law, local law say about when you can actually look at that information? Who is going to review that report? As you scale bigger and bigger, it might make sense for you to have a single person that's reviewing those records rather than leaving it to individual managers or somebody else that may not have the necessary training to be able to decipher if there is a business need justification or some other appropriately tailored requirement. The next thing that you'll want to look at is the storage and destruction of your records that you're receiving. This may be in your background check policy, or it may be in a separate document retention policy or a safeguarding policy, an information security policy, something of that nature, but you'll want to make sure that you've got the appropriate controls around how you're going to intake that information, what information you're receiving. First of all, is it an accept and reject, or is it an actual full-on consumer report? Where you're storing that, and then how you destroy it in the end once you've retained it for the length of time under the statute that you're looking at. The other piece, and this I put kind of an asterisk on this final bullet point here. So as you get bigger, procedures become more and more important. If you're a small company with a few employees and you talk often and you're all on the same page about how things are doing and going with your company, sometimes it's not as necessary for you to have written procedures unless, of course, it's required by law. But as you get bigger, written procedures can really become beneficial, and we'll actually touch on this a little bit when we talk about audits. But written procedures can provide employees consistency, and they can provide a method of doing processes that provide actionable requirements for your employees, and so they don't have to guess, basically. Everything is written out for them. They can follow a step-by-step procedure, and there's no questions. One thing to note with written procedures, if they are based on law, a lot of times it's good to note that law for future reference and then to do periodic checks of that law to ensure that the changes are captured. I'm sure many of you know that legislatures will go through an annual review sometimes of their laws or regulations, and so it's really important to pick up on those issues that they're addressing and if there's been any changes that would affect your procedures. Next slide, please. So training, and this goes back to your policies and procedures. Again, I think it's important to have a training policy in place, but you generally should be doing an annual training covering general policy and procedure requirements related to your background check report, which means document retention and storage again. More frequent training of employees who have direct access to consumer report information is suggested. This becomes particularly important as you scale your operations into a larger space. We suggest that when you conduct a training, either annually, a training that is done more frequently for specialized employees, or any training that is done in a remediation effort, you document the attendance of that training and a brief summary of that training. I suggest as well, depending on the training size, you include the presentation that was given. We'll get into audit in the next slide, but just kind of make a mental note that if an audit does reveal there's an issue, training often is a good remedial effort. Next slide, please. So auditing and identifying systemic issues. I have found recently that employers are kind of scratching their heads, especially when it comes to all the changes in state law that are going on right now. Okay, there's changes, almost daily it seems. How do we go back and audit our procedures to ensure that we're complying with law, that we've done it upon the change of the law, and what do we do to fix if we're not? This is a huge topic, and I want to put another asterisk here that I'm identifying very high-level tasks that you may want to consider, but it suggests consulting with your attorney as well, because this can be a significant issue for a lot of employers, especially as you get bigger. That being said, here are some things that you can do to kind of audit and identify systemic issues. Test the controls that are contained in your procedures. And I said before that written procedures were helpful, and this is why. A written procedure provides you with a written task that you can then test. So you go back through your procedures and you identify employee A should have done 1, 2, 3. When you go through your auditing, you look to see and ensure that employee A did 1, 2, 3 according to the policy. You make notes if that was not done, and then you identify in a remedial effort and you carry through with that. And then depending on the situation, you may want to do additional audits based on that evidence that you found. Some things that you can look at to determine if there's some systemic issues aside from testing your procedures is whether or not there's been any disputes or complaints issued to your company. Are people complaining that a certain employee just, was disrespectful with respect to their conviction, or that you shouldn't have looked at their conviction, or it wasn't right? Those are all things that you want to take note of, take stock of, and then record them so that you can identify if there's an issue that's beyond just a 1 or 2 incident type thing. Always look at your forms. Look at your forms. I can't stress this enough. When you're going through your pre-adverse action, your adverse action, your authorization, your disclosure, those cannot be reviewed enough. And then the last important thing to do is that all of these results should be compiled and it should be reported up to senior management or your board of directors so that systemic issues are identified and the senior management and the board can take an initiative to address things further if needed. Next slide, please. So one of the ways that you go about ensuring that your process is consistent is to ensure that in compliance, is to ensure that you're working with a consumer reporting agency that takes compliance seriously. How do you identify that? Well, look at your service agreement with the consumer reporting agency. You should have certifications and that you're complying with the FCRA and the EEOC regulations that you're required to comply with, and that you're required to obtain the appropriate authorizations and disclosures. You should be identifying a permissible purpose, which in this case will likely be employment. And you'll notice that a compliant CRA will also verify that your entity is a legitimate employer, that they are a legitimate entity, most likely conducting background checks on an employee under the Fair Credit Reporting Act. A lot of times compliant CRAs will provide you with sample disclosures and authorizations. They'll provide you with certain notices under the Fair Credit Reporting Act, like notice to users of consumer reports. They're required to give that to you, so you'll want to watch out for that. They'll also conduct periodic audits of their end user clients. A lot of times this will consist of saying, we received a dispute from a potential candidate of yours. Please provide us with the disclosure and authorization that was provided to this candidate so that we can make sure that you did have the appropriate authorization to pull this report. You'll also notice that CRAs who take compliance seriously actually do have an in-house compliance team that in many cases, their sole job is to keep up to date on the compliance responsibilities of their CRA. So those are kind of some high-level things to look at when you're looking at a consumer reporting agency and your own policies to determine that you're working with a service provider that takes compliance seriously as well. Next slide, please. In some cases, a consumer reporting agency will actually provide a service for you. They'll provide your pre-adverse action and your adverse action notice requirements. So I'm sure you're aware under 604B3 of the FCRA, you're required to provide a pre-adverse action notice. And then under 615, you're required to provide an adverse action notice if you indeed do not hire or make an adverse employment decision on that candidate or employee. A lot of times it's easy for a consumer reporting agency to be able to handle the service of this notice to the consumer on your behalf. It's important to keep in mind that those notices are still your responsibility as an employer. It's not the CRA's responsibility under the FCRA. So we encourage you to make sure your notices are accurate and up to date with state law and federal law. And that you are still responsible for those so that you ensure that you're keeping on top of your compliance requirements. Next slide. Okay, so to wrap this all up, what is our takeaway here? I think the first one that we want to kind of stress is consult with your legal counsel. Laws in the employment and especially consideration of criminal records for employment purposes is changing rapidly. And as Cynthia mentioned, it's not unheard of that we're going to see more litigation in this space than we already are. So we encourage you to consult with your legal counsel to make sure that you are compliant with all of your responsibilities. Be proactive. Put policies in place. Put procedures in place. Make sure you train your employees and you conduct periodic audits to ensure that you've captured any systemic issues and you've remediated them. probably the biggest piece to working in a compliance space is to partner with compliance service providers, and that would include a consumer reporting agency that takes compliance seriously. So we also encourage that. And I think that wraps up our presentation.
Thank you so much, Cindy and Meg. So we have a couple of questions here, and so we'll first start with one that's directed at Checker. So, it says, so we use Checker for our background checks. Do they provide us with the compliance certifications? So there's a couple of things that Checker does do to help end users with their legal obligations under FCRA. So in the front end, under our services agreements, we do lay out all of the certifications that employers are required to do under the FCRA to make sure that they're compliant. For example, that they're using it in compliance with the laws, and that they're seeking the authorizations and just they're providing the disclosures. In addition, even though those are employer obligations or end user obligations, we do help you in those in making sure that you're compliant by providing you sample forms. We also have functions on our platform to help with pre-adverse and post-adverse notices. So there's definitely ways that Checker does help end users with their compliance obligations. So the next question, if Meg and Cindy want to jump in. So if an employee lives in Idaho and you are located in Washington State, choose whichever law is the strictest and run the background check using that state's laws.
So the first step is to review both of those state laws and determine where they're applicable and who they apply to. That's the first step. The second step then is to ensure that if there's a little bit of gray area where you might fall into, depending on if you have remote employees, for example, then in that case, yes, taking the strictest state law is advisable. One other thing that I would like to note, though, is that when you're doing that, just make sure that you're consistent in how you're applying your rationale across different states and across different situations. That is where an employment counsel, someone experienced in consideration of criminal records at the state level, becomes really important.
Great, thanks so much. So another question we got is regarding the Syrah case in New York. The question is, so if I am not a direct employer, but I review the employer's background reports and adjudicate those reports on behalf of that employer in New York City, can I be held liable?
Maybe. I'm sorry, I don't have a better answer, but that is a concern. That is a concern growing out of that, out of the Syrah case. Is that yes, under those circumstances, there could potentially be some exposure. There's not a case that says that, but what is concerning is that the court's language in the Syrah case is very broad and seems to, at least could be read broad enough to incorporate someone who is just doing the adjudication process.
If I could just add to that, one thing that you'll want to look at is who is issuing those adjudication guidelines. Is it the person who's actually doing the adjudication and making that determination on their own, or is it something that is set and approved by the particular employer? So employers may have different adjudication guidelines. That's something to look at as well. But if you're exercising control in any way over a hiring decision, Syrah seems to indicate that there might be some additional liability there.
Great, thanks so much for that. Another question we've gotten is, so we don't have any policies or procedures in place for our hiring process. Where do we begin?
So I'll take that one. It's a great question. Begin by looking at where you're at. Consult with counsel. Look to what your practices actually are and how big you are. And then from there, you'll want to develop your procedures based on what you're actually doing and what you should be doing. So those two, an employment counselor, counsel experienced with looking at criminal records can help you with that. But oftentimes what you're doing and what you're required to do are different. So you want to make sure that your policies and procedures reflect the appropriate balance.
Great, thanks so much. So we only have time for one more question. So the question is as follows. So we think all of our current workers are independent contractors and not employees. First question is, how do we know for sure? And second, if they are independent contractors, am I still bound by the EEOC, ban the box, or FCRA?
I'll take the first one, Cindy.
Sure.
How do we know if we have independent contractors or employees? As I mentioned before, I think your starting point is to look at the control you're exercising over that person. Look at what your relationship actually is, not what you're intending it to be, not what you want it to be. Those two, again, can often be different concepts, so we encourage you to take a look at the control you are actually exercising over that person and then go from there. And Cindy, do you want to take the last?
Sure. On the last half of that, with respect to independent contractors and FCRA, there are arguments being made that independent contractors must be given the same disclosure and authorization as employees, and so it is a good idea to, even though your documentation won't refer to the independent contractor as an employer, it is better to comply with the FCRA than not to comply, because this is an area where, Meg, correct me if I'm wrong, but I believe the FTC takes the position that an independent contractor should be given disclosure and authorization. And with respect to the state laws, again, I think you are in areas where, I hate to keep saying this, but you are in a gray area. You have a lot of these statutes that are being drafted very broadly. They're not necessarily always drafted in terms of using the words employee and employer. They frequently are used in the terms of in an employment context. And when you use words like employment context, you can sweep in situations like an independent contractor. So, applying these procedures to independent contractors, it's a little better safe than sorry. I understand you want to maintain the independent contractor relationship, so you need to make sure that that documentation doesn't refer to it as an employee as an employer, but I think your safer bet for at least some of these is to follow the requirements.
Great. Thank you so much, Cindy and Meg. That was really helpful. And thank you for all the attendees who joined today. We will be circulating the presentation, and also we'll have it up on our website for you guys to access. Have a great day.
Thank you.